Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bichard. Today I read the case Write-In Pritt, Campaign vs. Hechler, 447 SE 2D 612, West Virginia Supreme Court of Appeals, 1994. Friends, today we're going to talk about a case that involves nuances. So get your thinking caps on. Friends, this case describes and defines what it means to be a third party. What is the definition of a third party? In most cases, that's not something that's under contention. Although our third party friends have to fight many things in these other cases, they don't have to fight the definition of a third party in most cases. Here they do. So you'll have to decide for yourself whether this qualifies as a third party. So let's read from the record. It says, quote, "This proceeding arises pursuant to two certified questions from the Circuit Court of Kanawha County pertaining to whether Respondent Ken Hechler, in his capacity as a West Virginia Secretary of State, is required by law to recognize the Mountaineer Party as independent political party and grant the same ballot access," end quote. And then it continues. It says, quote, "On December 23, 1993, petitioners Frank Young and Carol Jett, the co-chairmen of the Write-In Pritt campaign, instituted a declaratory judgment action in the Circuit Court for determining whether the Write-In Pritt campaign, in its capacity as a duly authorized political action committee, herein referred to as the PAC, constituted a political party as contemplated by the provision of the West Virginia Code Statute 3-1-8, 1994. After evidentiary hearings were held below on February 9th and 10th, 1994, the Circuit Court certified the following questions to this court," end quote. It goes through a list of specific things. Carol Jett. Is Carol Jett a male or a female? If Carol is a female, that's a sexist terminology. It says co-chairman. If Carol's a male, the terminology is fine. I don't know about Carol Jett. I never met Carol Jett, never heard of Carol Jett, so I don't know if Carol Jett is a male or female. I never heard of the Mountaineer Party, so that's another first, friends. Another new third party, provided that this qualifies as a third party. We're going to be discussing why this is an issue. The footnotes here talk about this issue. The footnote number 1, it says, quote, "Although this political action committee was originally designated as a Write-In Pritt campaign, pursuant to the original documents filed with the Secretary of State, they changed their name to the Mountaineer Party on May 9th, 1994, just shortly after the Circuit Court's certification order," end quote. Thus, the crux of this is it a party in name only, or is it a genuine third party? That's the question for the day, friends. Also, we could ask, does it matter? Does it matter what the state qualifies it as a party? How would we qualify this as a party? So let's see the further reasoning. It says, quote, on January 31st, 1992, Charlotte Jean Pritt entered the 1992 May primary election campaign as a gubernatorial candidate. In registering her candidacy with the Secretary of State's office, she certified that she was a registered Democrat and advised that her finance committee would be known as the Pritt for Governor Committee. Ms. Pritt was defeated by incumbent Governor Gaston Caperton during the May 3rd, 1992 primary election. Other than filing updated financial reports related to the primary, it appears that the Pritt for Governor Committee has become inactive since the primary election. On August 25, 1992, petitioners Young and Jett formed the PAC. In the PAC's Statement of Organization, petitioners state their intent to promote the candidacy of Charlotte Jean Pritt for Governor of West Virginia. Additionally, the PAC advised Respondent Hechler that it would be supporting or opposing other candidates and ballot issues, that the organization would be active in statewide, county, or district political campaigns in West Virginia. When the general election was held on November 3, 1992, Ms. Pritt received 48,872 write-in votes for governor. This amount constituted 7.4% of all votes cast for the gubernatorial position. Petitioners assert that they are entitled to recognition as a political party based on language of West Virginia Code Statute 3-1-8. End quote. 48,873 votes is quite the showing. If she's a Democrat, we don't care. But if we want to consider her a mountaineer, that's impressive. That impresses us, friends. That rocks. We want mountaineer parties to get votes. We don't want Democrat people to get vote. This is not a fusion voting issue, it appears. It's a different issue. That's why nuances come into play. We've had other cases on this podcast that have dealt with fusion issues. New Party versus McKenna, I believe, was the name of one such case we discussed. So they are talking about whether this political action committee qualifies as a third party. I've never heard of the issue before, whether somebody wanting to form a political action committee is the same as a political party. This issue has never come up before in a trial I've seen. That's why it's interesting to keep reading new trials. New issues come up. So let's see what they also have to say. It says, quote, the parties have stipulated that Ms. Pritt is a Democrat, has always sought and held office as a Democrat, and has been quoted as saying that she will always be a Democrat. She remained a registered Democrat through the 1992 gubernatorial campaign, and she remains the same today. The parties also stipulated that Charlotte Jean Pritt never authorized a write-in Pritt campaign to take any action on her behalf during either the primary or general elections in 1992. It is also stipulated that at the time of the general election, the write-in Pritt campaign had no candidate nor democratically elected hierarchy. Under the logic employed by the petitioners, any political action committee formed prior to the general election, which happens to include as part of its name the name of a candidate that obtains more than 1% of the vote, is automatically entitled to be designated as a political party. We do not believe that the argument advanced by petitioners comports with the intent which underlies West Virginia Code Statute 3-1-8. Moreover, were this the case, as the respondent accurately argues, we are limited only by our imagination as to the number of political parties that could come into existence through such mechanism. End quote. Would it be a bad thing if an unlimited number of political parties came into existence through such a mechanism? I'm not sure why these people are so adamant about advancing Ms. Pritt. She seems to be a staunch Democrat. Staunch. Stalwart. Hardliner. So her friends want to form a third party to advance someone who wants to stay entrenched in the two-party system. So friends, what's this all about? Let's read another footnote because this is going to illustrate what's going on here. It says, quote, in actuality, there are two political action committees formed to support the Charlotte Pritt campaign. To demonstrate the absurdity of the petitioner's argument, the other political action committee was entitled Draft Charlotte Pritt for Governor Campaign and gave as its statement of purpose to elect the most beautiful, intelligent, compassionate, and imaginative of all possible candidates to the highest state office. Under the petitioner's theory, this other political action committee should similarly have the same right to be designated as another independent party on the ballot. End quote. Do we want them to be another independent party on the ballot? Those statements appear to be hyperbole. If Charlotte Pritt is the staunch Democrat she asserts she is probably not the most intelligent, compassionate, or imaginative of all possible candidates. She could very well be the most beautiful, as that's a different quality altogether. She could be a beautiful person on the outside, yet still be a staunch Democrat. So friends, what do they ultimately decide here? They say, quote, "Yet we note that there is no evidence to suggest that those individuals casting votes for Ms. Pritt wish to be affiliated with the PAC's efforts to gain ballot access for a third political party, or to join such a party. Accordingly, the PAC, cannot claim to be an affiliation of voters or an organization for the purpose of West Virginia Code Statute 3-1-8, where there is no evidence to suggest that those who voted for Ms. Pratt as a gubernatorial candidate had any other shared intention besides casting a vote for a particular candidate. There's nothing to indicate that these voters intend to abandon their party affiliation to become members of a new party. Accordingly, we hold that a political action committee does not qualify as an affiliation of voters representing any principal or organization within the meaning of West Virginia Code Statute 3-1-8. Based on the reasoning set forth herein, we respond to the certified questions in the negative. Having answered the certified questions, this case is hereby dismissed from the docket of this court. Questions answered, case dismissed." End quote. I've never seen a case that was just about answering questions before. So I never saw it conclude as questions answered. Friends, what do you think about all this? Would you ever form a PAC that would endorse one of the two-party candidates and then want the PAC to be a third party? Maybe if you don't live in West Virginia, it might work somewhere else. What do you think about this strategy, friends? What do you think? Whatever you may think about this, there's one thing for certain. That's we are here to advance third parties. So let us advance them. Long live third parties. Goodbye.